Good morning, everyone. Welcome to Iibs Ias Academy. Today, we're going to discuss important articles in Indian Constitution Part 3. I'm Ashok, Master's graduate from IIT Kharagpur. I have been working as an assistant professor in Iibs Ias Academy. I'm an author. I have written about 3 books for UPSC Civil Services aspirants. You can get those books on Amazon and Flipkart. So today we're going to discuss Article 12 and Article 13. Already the previous articles we have discussed, so the links will be in the description below, please follow them. And what are these Article 12 and Article 13? The Article 12 is giving the definition of the state, and Article 13 is talking about the laws inconsistent with or in derogation with the fundamental rights. So the first one, what constitutes a state? What comes under the definition of the states? What organizations comes under the basket within the basket of states? This is Article 12, and Article 13 is talking about the fundamental rights. So when you're talking about the fundamental rights, we have about from Article 12 to 36. So these are our fundamental rights. So in these fundamental rights, we have these 2 preliminary articles which are actually talking about the laws inconsistent with or in derogation with the fundamental rights. So if there are any laws that are made, or if there are any laws that are previously made that are enforced, so what is the fate of those laws? So this is what Article 13 is dealing with. So we'll see what is Article 12 and Article 13. Article 12. The first, let us see one judgment recently. The Delhi High Court has given judgment in Sanjay Bahal versus Union of India and others case that the United Nations is not a state within the meaning of Article 12 of the Constitution of India and not amenable to the jurisdiction of the court under Article 226 of the Constitution of India. So 226 is talking about the jurisdiction of the court, right? So under this jurisdiction, United Nations is not a state. So United Nations is not a state. That's why under the Constitution, that will not come under the jurisdiction of the state. So our court cannot direct anything to the United Nations. So with this article, so the question arises: what is a state? What constitutes a state? So we'll see the definition now. So as per the definition of the state, as per the Constitution of India, the state includes the government and the Parliament of India and the government and the legislature of each of the states and all local and other authorities within the territory of India and under the control of the government of India. Right? The local and other authorities. You please remember the word other authorities within the territory of India under the control of the government of India. So we are talking about the government and the Parliament of India, the government and the legislatures of each states, and all the local and other authorities within the territory of India. So this is what the state is. So now the question comes: what are other authorities? Right? What are other authorities? So what is the definition of other authorities now? Is there any ambiguity in interpreting the other authorities? This we have to see. So, around the phase of Article 12, other authorities has been evolved over time. The question of the meaning of other authorities has actually come into the picture. So, what is the meaning? So, earlier there was a restrictive interpretation of the word other authorities. What is this restrictive interpretation? As you can see, right? Authorities exercising governmental and sovereign function would only be covered under the authorities. That means only the governmental bodies or the only authorities, right? This was the restrictive interpretation. Later, the liberal interpretation has evolved. So, as per the liberal interpretation, it is not necessarily the government authority, right? Or to be engaged in the sovereign or the governmental function, but the others also comes into the picture. What are the others? The statutory bodies, right? So the state electricity board, LIC, ONGC, IFC also comes under the other authorities, the statutory bodies, not only the governmental bodies, the independent bodies, right? So which are not necessarily the authority to be engaged in the sovereign and the governmental function. They are not the sovereign bodies. They are not upholding this. They are not functioning for the sovereignty and the governmental aspects of the India. But still, they also falls under the part of other authorities. Thus, falls under the definition of state. Thus, falls under the definition of state. And next one. there is a judgment which has given the 5-point test to see whether a particular organization falls under the definition of state or not. So, R.D. Shetty versus Airport Authority of India, in this particular judgment, the Justice P.N. Bhagwati gave 5-point test, right, to determine whether the body is an agency or an instrumentality of the state. Right? What are those 5 points? The first one, the financial resources of the state, where state is the chief funding source, that is, entire share capital is held by the government, right? The total share government, the PSUs, right? So the public sector undertakings or the governmental sources, right? Funding is through the state. The next one, deep and pervasive control of the state. The control of the state, it has to act in accordance with the regulations of the state, and the functional character being the governmental in its essence, meaning thereby that its functions have public importance or of any governmental character. The public importance or governmental character. So that is a functional character of some body. And a department of government transferred to a corporation. Transferred to a corporation. Any kind of road transport corporation, right? The department of a government transferred into a corporation. And the last but not the least, the fifth point, that enjoys the monopoly status which states conferred or is protected by it. So if there is any body that has the autonomous status and also it is protected by the government, so that falls under the definition of the states. So these are the 5-point tests that ought to be done to determine whether an organization or an entity falls under the definition of a state or not. Next one, judiciary. Does judiciary falls under the definition of a state? So if it does fall under a state, if there are any changes that are done, because the judiciary is such a body which has to uphold the fundamental rights, and what if the judiciary itself makes something which is in derogatory with the fundamental rights? So does the judiciary really fall into the definition of a state or not? So if it falls under the definition of a state, does all the fundamental rights applies to the judiciary or not? So does it have to follow the definition of a state when it comes to providing the justice? So we have a famous judgment, Rupa Ashok Hurra versus Ashok Hurra. The apex court reaffirmed that the rule that the no judicial proceedings could said to violate any of the fundamental rights, and that is a settled position of law that superior courts of the justice did not fall under the ambit of the state or other authorities under Article 12. Right? So the judiciary, when it is giving a verdict, when it is giving justice or during the judicial proceeding, that does not fall under the ambit of a state or other authorities under the Article 12. This gave the rationale that the superior judicial body, when it is acting judicially, would not fall under the definition of the state, but when it performs any administrative or similar functions, right? Only when it is giving the verdict, when it is going for the judicial proceedings, only in those circumstances the courts does not fall under the definition of a state, but for the administrative purposes that does fall under definition of a state. That, like conducting examinations, it will fall under the definition of a state, and that remedy could be sought in that context only in case of violation of the fundamental rights. If there are any violation of the fundamental rights when it comes to the conducting of examinations or going for the administrative functions, only in those cases the court can be affirmed or court can be seen as a definition of a state. Or when it comes to the judicial work, right, when it comes to the judicial proceedings or giving the verdict, so in those cases the courts cannot be seen as a state. So this is the standard of judiciary when it comes to the definition of state, Article 12. And now Article 13. So Article 13 is talking about the laws inconsistent with or in derogation of the fundamental rights, or in derogation with the fundamental rights. So in this we have 4 subclauses, right? 4 clauses. The very first one, Article 13 of 1, states that all laws in force in the territory of India immediately before the commencement of the Constitution, insofar as are inconsistent with the provisions of this part, shall, to the extent of such inconsistency, be void. Right? So it is talking about the laws in force. Laws in force, right? That means the laws which are coming before the commencement of the constitution, 1949, or precisely the constitution coming into force in 1950, right? Jan 26, right? Before this, if there are any laws that are inconsistent with the fundamental rights, that ought to be void, right? That will be nullified, that will be no longer functional. This is what article 13 of 1 is talking about. And article 13 of 2, the state shall not make any law that takes away or abridges the rights conferred by this part, and any law made in contravention of this clause shall, to the extent of the contravention, be void. That means state cannot make any law that will curtail the rights of the fundamental rights. That means I have right to equality now. So tomorrow the constitution cannot come and frame a law that right to equality will not be there, or right to life will not be there, the freedom of speech will not be there, or constitutional remedies will not be there. No fundamental rights can be curtailed, right? The state shall not make any law which abridges the fundamental rights, or which withdraws the fundamental rights, or any law that is inconsistent with the fundamental rights. And the third, article 13 of 3 is stating that in this article, unless the context otherwise requires, the law includes. So it is talking about law. What is law? What is force of law, right? The law in force of law. So these are the two things that this clause is talking about. So the law includes any ordinance, order, bylaw, rule, regulation, notification, custom or usages as well. The customs or usages are not in general sense but in the legal sense, right? Having in the territory of India the force of law. The laws in force includes the laws passed or made by the legislature or other competent authority in the territory of India before the commencement. The law in force is before the commencement, and the law states that after the commencement no such law are to be brought, and not previously repealed. They are not previously repealed, that are in force, notwithstanding that any such law or a part therefore may not be then in operation either at all or in particular areas, right? So even if that law is non-functional, so, or even if you have committed some particular crime which was previously a law but now it is void, so you are punishable because of it, right? And nothing in this article shall apply. This was added by the later amendment, article amendment 24, right? So CAA 24, Constitutional Amendment Act 24. Nothing in this article shall apply to any amendment of this constitution made under article 368, right to equality. So this is the right to amend the fundamental rights. So we'll see whether these fundamental rights can be amended or not. The first one. So coming to the judgments on article 13. Coming to the judgments on article 13, the first one. Keshwan Madhavan case, Madhava Menon versus the state of Bombay in 1951. Right? It is saying that there is no fundamental right that a person cannot be prosecuted and punished for an offence committed before the constitution came into force. So far as past acts are concerned, the law exists. Right? So it is talking about the person who has committed the crime before the constitution came into force. Right? It is saying that even though it is there, the fundamental rights, if a person, right, there is no fundamental right that a person cannot be prosecuted or punished for an offence committed before the constitution. So if he has committed before the constitution, and so the fundamental rights came into force later, so what will be the case on that particular person? Because my dignity is removed, right? So defamatory comments were done on me, but the constitution did not come into force. Can I really file a case on him? Yes, definitely, right? As the fundamental rights are concerned, so there is no fundamental right that a person cannot be prosecuted. That means against the violation of any fundamental rights, any person can be prosecuted if it is violated, right? This is the judgment. And the next one, do non-citizens have the rights under article 13 of 2? That means if there is any law that is made in violation to the fundamental rights, right? So what will be the case for the non-citizens, right? Do they have the same rights? So that is the judgment of state of Gujarat and another versus the Sri Ambika Mills Limited, right? In this, the court has observed that the fundamental rights are not given to the non-citizens, so this law doesn't apply to the non-citizens. You can see, when Article 13 of 2 uses the expression void, it can only mean void as against persons whose fundamental rights are taken away or abridged by the law. Right? The fundamental rights are abridged by the law. Only then it becomes void. But if those fundamental rights doesn't apply to those people, right? If those fundamental rights, abridgment of the fundamental rights by law doesn't apply to the individuals, that means the non-citizens, so that means the expression what does not apply to them, right? So the law will be upheld only for the non-citizens, but fundamental rights cannot be curtailed to the citizens of India. Fundamental rights can be curtailed to the non-citizens because that law doesn't apply to them. The law might be stillborn so far as the persons, entities, or denominations whose fundamental rights are taken away or abridged. Still, there is no reason why the law should be void or stillborn as against those who have no fundamental rights. That means for the non-citizens, right? So why should it be void? Right? There is no reason why the law should be void for the non-citizens because the fundamental rights doesn't apply to them. And next one, do personal laws falls under the ambit of Article 13, right? So does abridgment of the rights, if the laws are made under the fundamental rights, if the personal laws are in violation to the fundamental rights, does Article 13 of 3 falls under this category? So in the state of Bombay versus Narasu Appa Mali case, right? The expression personal law, the court has observed that the expression personal law did not include in the definition of law or law in force, right? The Article 13 of 13 is giving what is law and what is law in force, right? In that, the personal law was not mentioned, as you can see here, right? It is talking about the law includes any ordinance, order, bylaw, rule, regulation, notification, customs, and usages. But it did not use the word personal law. Is not used in Article 13 because, in any opinion, the framers of the Constitution wanted to leave the personal law outside the ambit of the Part 3 of the Constitution. This is the observation of the Supreme Court, right? They must have been aware that these personal laws needed to be reformed in many material particulars, and in fact, they wanted to abolish these different personal laws and to evolve one common code. When it comes to the one common code, what is the proof that they really wanted one common code abolishing the personal laws? So we have DPESP Article 44, Uniform Civil Code. So, in the directive principles of the state policy, we have Article 44, which is talking about the Uniform Civil Code. Right? We need only one code of law. Yet, they did not wish that the provisions of this personal law should be challenged by reasons of the fundamental rights guaranteed in the Part 3 of the Constitution, and so did not intend to include these personal laws within the definition of expression laws in force. Right? This is what they have said. But later it changed. Right? So yes, the personal laws also falls under the ambit of Article 13 of 3. How? Right? So we'll see the other Supreme Court judgments. The Ahmedabad Women's Action Group versus the Union of India, 1997. The Supreme Court held that if religious personal laws are a part of the codified laws by the legislature, then the codification must be for the fundamental rights. So they have to be in accordance with the fundamental rights. If there is any violation, if there is any law or the codified law that is in violation to the fundamental rights, that stands void. And next one, Shayara Bano versus Union of India and others case, which is also famously known as triple talaq case. Right? Triple talaq means if you say talaq, 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 there will be divorce. Right? The Honorable Supreme Court had an opportunity to observe that the inclusion of the personal laws in the Article 13. So the personal laws are also included in the Article 13 in this triple talaq judgment. But the court believed that since Shariat law is a statutory law codified by the Central Legislative Assembly, the rights with the Muslim men to pronounce triple talaq and get divorce is arbitrary and unreasonable. Alright? So triple talaq has been criminalized. Right? Triple talaq is clearly arbitrary and unreasonable. So it has put under the ambit of Article 13. Right? So it is codified by the central legislature and statutory. So it does fall under the ambit of Article 13 of 3. And the next one, India Young Lawyers Association versus the state of Kerala, which is famously known as Sabarimala case. Right, famously known as Sabarimala case. In this, the court said that the individual is at the heart of the Indian constitution, and as far as any law affect the individual, it could fall under Article 13 of 3. That means the individual was given the greater importance. That means any individual, if the fundamental rights are being violated, so immediately it will fall under Article 13 of 3. So this is what the court has observed. And as per 13 of 3 of the constitution, the law includes the custom or usage and would have the force in law. So immediately the force will be, the law will be enforced, right? As per the Article 13 of 3 of A, the law includes custom or usage. So this personal laws also falls under the custom or usage, or any customs that you are following, that falls under the custom or usage. So if it is in violation to the fundamental rights, if it is in violation to the fundamental rights, it stands void, right? So tomorrow we will be discussing the part 4 of Article 14. Part 4, Article 14, right to equality, right? And if you have any queries in the articles we have discussed, please put down in the comments below. And please like, comment, share and subscribe. Thank you.